Welcome to the Nitty-Gritty Law School. The Nitty-Gritty Law School was started by a fellow by the name of Bob Foster. And he recorded Roger Elvick's material, and he also sold stuff relating to trust. So I managed to stumble across him and bought some of the Roger Elvick tapes from him, and he then died of a heart attack a little while later. And his wife had asked me if I'd be willing to answer questions from people who had bought his tapes. And I said, sure, I'd be happy to. But I needed a hotline to Roger Elvick so that if I got stuck on something, I'd be able to get answers. So she arranged that, and I managed to get involved with about 150 cases. A lot of tragedy along the way. A lot of people paid a big price for their effort. Some people had some luck, but we worked out a lot of concepts. We made our mistakes, and we continue to make our mistakes, but at least we're improving and refining this. And so here we are. Now the Nitty-Gritty Law School is not a school, provides no certificates. I guess at best I could classify myself as the court jester. Okay? But I do share some information with you. And today we are going to concentrate on form. Now in the past we always concentrated on substance. What is a court? What is a sovereign? What's the relationship? And so forth. And all that information is delivered on other recordings relating to sovereignty. In this case, we're going to deal with form. How do you put a lawsuit together? What do you put on the page, and where do you put it on the page? So that's the basic thrust of what we're doing today. So I guess the first step is to get serious, so I will. As the sovereign of the court, I specify what the rules are. Okay? And if you're sovereign in your court, you say what the rules are. However, there's an important principle, and that is that you have to communicate with court personnel. You've got to communicate with the judges, particularly with the judges, with the opposing attorneys, if they're willing to communicate with. A lot of them know everything, so it's hard to tell them anymore. But you have to communicate. Well, the best way to communicate is to speak the language of the listener. There's a lot of people who put together lawsuits, and you've seen them probably. They've got giant letters, 1.5 inches high on their papers. They have all sorts of claims. They want the support of Yahweh and that sort of thing. But I view the court process as being very secular, down to earth. And I deal with the real world rather than the spiritual world. Okay? And it's important that when you put together your paperwork that you follow the customs. In one sense, you're the king, you're the sovereign. You can lay out all the rules. You can set the rules of court. You can set the laws that you're charging with. And of course, the jury will sit in judgment of your law and discount it if necessary, if in their opinion they don't like it. So you have that as the great limiter on your arbitrariness. I think I've explained in the past how I really get torqued out over pink shoes in my presence, and so anybody who wears pink shoes in my presence is going to suffer the death penalty, and because that's important to me. When I charge somebody with violating my law, that defendant has a right to call on a jury, and one of the big limiting factors, now it doesn't mean I'm admitting I'm wrong, but one of the great limiting factors is that it's really tough to find a jury that will support my law. And so far I've had no convictions. Now on the other hand, if I also have another law which says that I have a right to walk down the street unmolested, provided that I'm not bothering anyone else. You know, I'm simply walking along the sidewalk. So if somebody comes from behind and knocks me down and breaks a bone, and I come back and charge him with assault, my law against assault, and my penalty is 30 days in the Huskow, the probability is that I would find a jury that would support that. I think I could get a conviction on that one if I had that law, no assault, that's unprovoked, and 30 days in jail. So the common law, again, is basically public opinion. And you have to, if you do have a case, whether you're right or wrong in your own point of view, if you do have a case and you run it through the court system, you have to remember that you have no physical power. Okay, you can have all the law on your side, but if everybody's against you, then you do not have the physical means to enforce it. We have no guns. We have no control of the paychecks. So all we can do is win our cases and then rely on the very people that sometimes we're in conflict with, rely on them to enforce it. Just to kind of review a little bit of the concept here, because it leads into where we're going, it's very important that you have to speak the right language. Language is important. You have to learn the legal language. Now, is that in focus for everybody? Everybody can see it okay? Close? Let's see if I can improve this just a shade. More better? Anyhow, so you have to speak the right language, and in this case the language is English, legal English. Okay? You all know business English, or formal English, it's also known as. You all know how to speak slang. You know, when a lady who's wearing a cool outfit comes in and you let her know it's a really hot outfit. It's also important to know what a court is. And a court basically is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. See, when you're the sovereign and you bring someone in, you're the sovereign plaintiff, you already know he's guilty. Okay? Otherwise you wouldn't be bringing him in. And he already knows what he did. He either knows he's innocent or he knows he's guilty but lies and says he's innocent. But either way, what goes on between you and the defendant, there's nothing that either one of you can say really to each other that you don't know already. So why have a court? Well, the reason is because you want to convince the rest of the world. This is a stage. And that's the number one rule. That is the rule in all capital letters. Okay? Never mind the legal definition of a court. The real purpose of the court is to put on a show. And you want to make it a good show. And who is it that you're putting the show on for? Who is this rest of the world? Well, it's the judges, the lawyers, the sheriffs, the jury, the clerk, the jury. Right. That's who you're putting the show on. Well, these people come in with all levels of education, all levels of ignorance, all levels of arrogance, all levels of compassion. You got everything there. So you've got to get through their shells, particularly of the people who are not on your side. You've got to get through to them. And so how do you get through to them? Well, you speak their language. And so that's what we have. We have this language here, as I said in the beginning, and then you also have the court. And now you're going to put that language in the court into your paperwork. And that's what we're here for today, is the form of the paperwork. Now, a lot of people place a lot of importance on form. Now, the general rule of thumb, the legal maxim is that form is superseded by substance. That's the general rule. But the fact is, when you look at the courts and how they operate, when you know the government courts, you'll find that they put form ahead of substance. So we have to have good form when we go in there. So, as a starter, let's go down to procedure. And specifically, I want to talk about court papers. Whenever you want something from the court, you write a letter to it. Now, when you write a business letter, there's a format that you're familiar with. You put your return address and date on the upper right-hand corner, and then on the left side you put the name and address of who the letter is to, and then you say, "Dear Sir," or "Dear Madam," or whatever. And then you go into the body of the letter, and then you have the signature block. That's the form you use when you write a letter that's formal to another person or business. When you write a letter to the court, they don't call them letters, they give them a different name, but it's really what you're doing. So the first letter you write to a court is called a complaint, or it's called an action. And you can write other letters to the court, those are called motions. Or if you're on the defending side, you write a letter to the court saying that, hey, the other guy's wrong, and here's my point of view. So basically, to accomplish this, you have basically what you do is the very first thing, you take your claim, which is item number 2 on this list. You take your claim for damages to the court and the clerk, and you also take your facts. You also have a brief. In the brief you discuss what the law is, you discuss what the facts are, and you discuss what how this all connects together. And then you also then get from the clerk a summons. And you take that summons, you package it with the claim and the facts and the brief, and you deliver it. And then you, after you've got it delivered, and it has to be delivered by somebody other than yourself, somebody who has no stake in the outcome of the case. Since you have a stake in the outcome of the case, you're not trustworthy in that respect. The court wants to be somebody that's what they say is arm's length. In other words, somebody over whom you have no control. And that person serves it and files a paper with the court, files his own little letter, which is called a proof of service, where he tells the court, okay, I did deliver this is how I delivered it, this is who I delivered it to, and so on. Then as part of this package, you also have the proposed judgment, which is usually called a prayer. At the end of your complaint, you have this thing called a prayer, which is prayer. All it is you're just saying to the court that based on all this other information, I want you to give me whatever it is you're asking for, X dollars in damages, or an ordering the other person to do something or stop doing something. But that vacate the planet. Yeah.
For the bar association.
Yeah, for the bar association, right. But the thing is that understand that this stuff it has its complexities, it's true, but really there's nothing magical about papers, the court papers. You're basically writing a letter. You're putting down your point of view. However, there are certain ways that they do things. But that's your very first paper that goes into court is the complaint has these elements. After you're in court, you have more papers, but they tend to conform to this format up here. You basically have a notice of a motion, okay, where you give the other person a notice. Well, that's kind of like the summons. You notice really the same things are there, but they change the names, part of their formality. You have a motion, you have certain facts, which you put in by affidavit or declaration. You have a brief, and the brief contains the points and authorities, which basically means that you have the point being made, the authority that supports it. In other words, you quote laws or whatever. And then the argument in support of your point. And then you have to serve it on the other person, and you have a proof of service. That way the court knows who got a copy. And then, and along as you're doing that, you also throw in a proposed order, like the prayer in the complaint. For a motion, you have the proposed court order. And by the way, the attorneys are normally